Hi, everyone that's now joining. We're just going to give it a couple minutes before we get started. We're just going to give it another minute or two and we'll get started shortly. Okay, we'll just give it one more minute and we'll get started. Okay, thanks everybody for joining us today. I'm continuing our financial well-being series, planning today for tomorrow. Back again for a third year is Daniel Timins. In this two-part series, Mr. Timins is going to educate us on the things we need to take under consideration when planning ahead to help those when we are no longer here or assisting those who may need our help. As always, we'll hold questions into the end, but you can type those anytime into the question box. And with that, I turn it over to you, Daniel.
Great, thanks so much. Thank you, Kelly, Daniel Timins. We've been here before. This is the third year in a row. More portly than I was last time, and I didn't bring my man Spanx, but I think we're going to be okay. You're going to avoid seeing my horrible face for most of the presentation, I believe. So, this is the first of a two-part series that we've done in the past for Nielsen's, and we're going to be doing it again. Right now, we're doing it on the 23rd of October, 2019, and we're going to be doing our next one on the 30th. That is next week at a similar time. Today is our first of two parts that we're talking about preserving wealth during your life and thereafter. This is an estate planning discussion regarding living documents, Medicaid, and money transferring options. The reason we go through these things is because this is one of the ways that people are able to both accumulate and transfer wealth or inherit wealth, depending on who the individual is. If I say anything off color, that's just kind of the way that I talk. I apologize. Complain to HR or someone else. Probably perfectly okay. So I'm going to get rolling, and I want everyone to feel free to keep questions rolling in. I just may not get an opportunity to answer them along the way. It just depends. So let us begin without further ado. I am going to commence the presentation. Very good. So the first thing I have to do is I have to show you a disclaimer. Once you've seen it, you can't unsee it. All right, great. So what are we talking about today? We're talking about saving money on taxes, healthcare costs, and court costs. We're talking about transferring money to other people and preserving family wealth. The whole idea of what legal estate documents are, what type of taxes we face, and which are the quote-unquote better or worse taxes, if you can imagine such a thing. Types of investment accounts, Medicare, just briefly. I'll probably run through Medicare pretty quickly. And Medicaid, I will spend some time on, not because it applies to most of you directly, but it may apply to a family member, particularly aging family members, or if you have a family member who's younger but disabled. So I will talk about that because it is an area that requires a good deal of discussion. So the first thing we are going to talk about, or we're going to get right into it, are the different legal documents that are created during your life and thereafter. And there are five we're going to be talking about. There's the power of attorney, the healthcare proxy, the living will, the last will and testament, and last but not least, different types of trusts. Now, depending on what state you live in, the name of the document may be a little bit different. Some states call the healthcare proxy the healthcare power of attorney. But basically speaking, the general content of what's going to be there is going to be the same thing no matter what your state names that document. I just defer to and state that it's New York only because I live here in New York and this presentation is coming from New York. So yet another person who thinks New York is the center of the world. Power of attorney. This is an important legal document because it's a document, and I always try to go through my presentation as it's numbered. It's a legal document that names another person or persons who can make financial decisions for you, including sometimes gifting your money to other people while you're alive. So here's an example. Let's say my wife says, hey, Dan, it's time for us to refinance the mortgage on the apartment. And I say, I have no time. I'm doing a webinar today. Have fun. She can go to that closing with my power of attorney document, and she can sign stating that I am signing Michelle as the person who is going to be updating this mortgage and refinancing, and I, Michelle, am going to be signing for Dan as though Dan signed himself. Realize that I was not incapacitated. People think the power of attorney just means I've been hit by a truck, and so now someone else has to make financial decisions. In this case, I just punted. I said, Michelle, I'm willing to have you do it. I trust you to do it. So that's why it's important, because your power of attorney can be in effect the moment that you sign it. And keep in mind that the term attorney in fact does not need to actually be an attorney. My wife, Michelle, is not an attorney, though she is my power of attorney. And the term attorney just means someone who represents you. So specifically regarding the power of attorney, each state has their own document. This is called the statutory form. New York only has one type of power of attorney, that is the statutory form. That's the one that the state prefers. Some financial companies have their own. If you work with JP Morgan Chase or Bank of America or Citibank, they may have the Citibank power of attorney, but JP Morgan Chase isn't going to listen to or follow the Citibank power of attorney. It's solely within that organization. So you want to create a state form power of attorney if you want to make sure that it's going to be valid at all financial institutions that are doing business in the state you live in. And again, you can allow this person who's called your agent or also your power of attorney or attorney in fact, the ability to pay your bills. They can write out checks to other individuals or service providers. They can change your investments from, your checking account. They can move it to a brokerage account to Bitcoin, and then they can move it back. And then buy or sell your stuff, your personal stuff. They can buy your furniture for you. They can sell the armoire that they always hated for you. And it has to be in your best interest. They can file your income tax returns, and they can bring lawsuits. So you see, a power of attorney has a great deal of control over your financial affairs, and that's the idea. Now, you may allow your power of attorney to gift your money. So here's an example. If I get let's say a single lady or a single man who has no kids and they don't really like their nieces and nephews so much, and they have friends, but they're not so hip on sharing money with those people, I will typically say do not allow gifting to that person. Because frankly, why are you going to allow your power of attorney to gift your money while you're alive to other people if you don't have someone other than a spouse or kids? Maybe a parent. Sometimes I see parents. It's pretty rare that people say friends. Maybe a longtime girlfriend or boyfriend. But that's about it. Now, the benefits of allowing gifting is that it allows you or the person whose power of attorney you are the agent on to gift for Medicaid planning. In other words, to qualify them for government programs. It's very important that if you're doing Medicaid planning that you have a power of attorney for the individual who's applying for Medicaid, because it means they're already most likely disabled to some extent and they may not be able to handle their own finances. They need you to do that, and they may need to qualify by getting their assets or income down, thus giving it to you or somebody else. Now, the negatives here is that if you do allow gifting, your agent could potentially run away with all your money. And people say, does this happen all the time? And I say, not really, but it's kind of like speeding. As long as you don't get caught, you can get away with it. So that turns off a lot of people to doing the power of attorney. I suggest that is not a good reason. If you don't have anybody good named, there are people, professionals who will do this that are insured. Now, this is important to remember. I've had people who have advanced degrees, people who run hedge funds, people who have multiple years of schooling, just assume the power of attorney can be used to write a will and then will continue after the time the person passes away. And the answer is, when you die, your power of attorney stops. And see, sorry about the noise. Like I said, New York centric, we have sirens every day, perhaps even every hour on the hour. When you die, your power of attorney is canceled. It stops. At that point, your will takes over. So your power of attorney is a true living document. Now, tips for the power of attorney: if you have an aging family member, bring them with you to their bank and financial institutions and make sure that you bring the power of attorney so that mom or dad can say, or Aunt Ruth can say, hey, I'm trusting nephew Dan to be my power of attorney. Please add him onto the accounts. It's easier to validate these powers of attorney when the principal, the person who's signing it, is present and they're stating it as well as showing the legal document. Now, you do not need an original power of attorney except for when you're transferring real estate. If we had more time, I'd explain why, but won't at this point. Now, remember, you should only appoint a person you trust. Like I said, your power of attorney could run away with all your money. They could write themselves out a check and run away to Florence. What a great idea, maybe for them, but not so much for you. So if this person you named has financial troubles, or they're kind of shifty, or they have drug issues, probably not a good choice to name as your power of attorney. I'm just going to put that out there. So you really need to find someone you trust. And if you don't have anyone natural that you can trust, like I said, there are people called daily money managers. I'm plugging them, even though I have nothing to do with them, who will be able to act as your power of attorney. I do work with some of them, but I don't get compensation or anything from them, just letting you know. Now, healthcare proxy. We've already dealt with your finances while you're alive. We look at a healthcare proxy. A healthcare proxy is, again, a legal document that names an agent. I call them a healthcare agent, but they are also known as a healthcare proxy, that can make healthcare decisions for you. You give them access to your HIPAA-protected healthcare information, your confidential healthcare information. It includes limitations on care. For example, I can see people who will say, I don't want another animal to suffer to maintain my life. So they will automatically get rid of certain types of medical treatment on their behalf because it's against their morals. Including limitations on organ donation. Some people don't want to give their organs. My experience has been about 50% of people do want to donate their organs, 50% don't. You can state that in your healthcare proxy, and it overrides what's on the back of your driver's license, which I'm going to submit to you do not want to have your organ donation request on the back of your driver's license, because then the state can do more or less whatever they want once you pass away. Not good. And then lastly, it allows or disallows your agent to continue life support. So if I'm in a vegetative state, this is the document that gives the healthcare proxy, the healthcare agent, the actual power to pull the plug when I'm in a vegetative state. Now, healthcare proxy may only be for a few hours. Let's say you're perfectly fine, but you're going in for something as simple as an appendectomy. They're going to put you under, right? Because you're not going to be awake to take out your appendix. That's something out of a horror movie, and a bad one probably at that. What's going to happen is you're going to be put under, and if the doctor says, hey, I see some additional inflammation here, some swelling, or I want to take out, like a few inches of the small intestines, that's going to be your healthcare agent who's allowed to do that. Otherwise, they're going to stitch you up, and they're going to say, hey, we saw some problems, but we didn't want to get sued. And you're going to say, I wanted you to fix that problem. So you may only need your healthcare proxy for a few hours. What happens to other people as they age is that some people may get dementia or Alzheimer's. They may have a bad stroke or Parkinson's. They can no longer make their decisions ever again. That's when the healthcare proxy locks in. So if you are unable to make your healthcare decisions and you have a healthcare proxy, you're going to be okay. It's just that you can't change your healthcare proxy anymore because you frankly can't do much of anything. Which brings us then to the living will. This is the quote-unquote pull the plug document. I like to say that a living will is neither a living document nor a will, because a will gives away money. This does not, and this says it's a living document. Here, clearly, we're pulling the plug. So it should probably be the dying non-will. But instead, we call it a living will. Some states call it an advance directive. I don't think that's really indicative either of what this document is. This document states what you would like to have happen if you are either in a terminal condition, which typically means give me a heck of a lot of morphine even if I lose my consciousness because I don't want to feel the pain. Probably a good idea. You're permanently unconscious. This is typically what we call a vegetative state. As is number 3, you are conscious but have irreversible brain damage and will never again regain the ability to make decisions or your wishes. The fact that someone has dementia and they forget your name doesn't mean that they've risen to the level of, hey, please pull the plug, stop tube feeding me, etc., etc. It's really a vegetative state, and that's a decently high burden. It's still like a gray area, but it is what it is, and it means you really have to be in a bad condition. Now, these are typically the things that people want to cease care on when they are in a vegetative state. They don't want mechanical respiration or cardiac resuscitation, meaning if their heart stops and they're in a vegetative state, don't bring me back. It's just going to prolong my being in a vegetative state. They don't want tube feeding or antibiotics because they're dying already. They want to die in dignity. Most people say they do want maximum pain relief, meaning that if they're sick, they want to have, their quote unquote morphine drip so that they don't feel pain anymore. Now, this is the important part and why I always start with powers of attorney and healthcare proxies. Many people can't think of people that they trust to name as their power of attorney or healthcare proxy. And if they get a stroke or they have dementia or they get into a bad accident and they can no longer make their healthcare and or financial decisions and they have none of these legal documents, someone has to make those decisions. The state of California, New Jersey, and Texas, as long as you're paying taxes, they really don't care about anything unless you get into like a barroom brawl. But once you can't make a healthcare decision and once you can't pay your bills, that's a problem for the state. They will have what is called a guardianship. And a guardianship is where a court will oversee your circumstances and they will name someone, which the term varies state to state, but here in New York we call them a guardian of the person. Some places call them a conservatorship, like in Connecticut. And that person is going to be in charge of your financial and or healthcare decisions. Sometimes it's a family member, sometimes it's not. If you don't have great family members, but you have friends that you would trust, but you don't have a healthcare proxy or power of attorney, once you become incapacitated, you're next of kin. The family that you don't like is the next in line to take care of you. So that's why these documents are important. And like I said, you can find other people to do this. You don't need to have the best choice on the planet. You can have people who do this for a living. Which brings us then to a last will and testament. This is kind of my favorite part of the presentation, not because all the sentences kind of wiggle back and forth. I don't actually do the effects. That's Giselle, who I appreciate. Thank you, Giselle. But sometimes it does distract me as well. Now we're going on to the last will and testament. It's important that people realize that a will is only part of people's estate plan. There's a heck of a lot more that goes on with an estate other than just your will. A will is a written legal document that attorneys like I put together. It's signed by you and witnessed by disinterested people. So if I'm leaving everything to, my ex-girlfriend and the person who's my caregiver, and they happen to be witnesses on the will, that seems a little suspicious, right? You're not supposed to have beneficiaries sign as witnesses to your will. They have to be disinterested. And I'll go back really quickly and say having the original document is incredibly important, all right? A lot of attorneys hold on to the original will, and you may want to say, hey, I trust myself. Hey, Mr. or Mrs. Attorney, you're like 88. And I'm like 45, and I trust me to hold on to my will more than you because you'll be dead in like another 6 weeks. So maybe that's a little harsh, but you get the idea. You probably want to hold on to the original will because the courts only want to accept original wills. An unsigned will or a photocopy will that is signed, but it's a photocopy, tends to not be any good. Number 3, the document states who gets what after you pass away. And it names a legal representative called your executor who winds up your affairs. We say the executor, quote unquote, steps into your shoes. They can do everything that you could do, 100%. That's what they mean by a legal representative. They can pay off your bills. They can get your old protected healthcare information. They can file your income taxes. They can clean out your closet. Plus, a will can name a preferred guardian for your minor child. Remember that no state just allows you to say who the child's guardian will be. They're going to look at 13 different factors, and they always ask, what's in the best interest of the child? So if you have, your molester uncle named as a guardian for your child, it's probably not going to happen. I don't know why you do that, but I'm just putting that out there as an extreme example. This is submitted then, the will, once you pass away, not while you're alive, but you can't give it to them when you're alive. I would suggest you don't. It's submitted to the court that oversees the probate process after you have died. When you're alive, no one's going to probate your will. The court wants to see an original death certificate. If you're alive, they're not going to allow, your shady nephew Bill to be able to go and take your money by saying you've passed away. And number 7, but only probated the will if there is money or guardianship that needs to take place. If you die with no money, there's no need to probate your will. You're broke. Your problems are over. Now, what is not transferred by a will? This is probably the most important slide in our presentation. I'll say that like 7 or 8 times, but this is number 1 or 2. What is not transferred by your will is incredibly important. Certain assets pass under a process called operation of law. Operation of law states that I know who receives this the moment I die. So if it passes under the legal procedure known as operation of law, it never transfers by the legal process known as probate, which is your will. So what are examples? The life insurance policy you guys have through work. You've named the beneficiary. My will could say, I leave everything to my wife, Michelle. But if my life insurance says, hey, this goes to my mom gets the life insurance policy. She's the named beneficiary. It never gets to the will because it's already been dealt with. We know who gets it the moment I die. My IRA or 401k, same thing. I've named a beneficiary. Whatever my will says is irrelevant. Jointly owned property. If I die, my wife goes to the bank in tears. She's already on the joint bank account. And then she confirms how little is in there, and then she cries even more. She doesn't need to do anything. I can say in the will, I leave all of my property, including the joint account made out to my wife, to my girlfriend, Fifi. And my wife still gets the property because she is a joint owner on the account. No need to look at the will. If you have small bank or brokerage accounts, might I suggest to you, you change them into transfer on death accounts. I can say on my account, for example, that this is the Daniel Timins checking account, transfer on death, also known as in trust for, the benefit of my sister, Jessica. And then Jessica just needs to show up with my death certificate to claim it. She doesn't need to go through probate because, we can all say it together right in front of your computer, we know who receives it the moment I die. It said Jessica. No need to transfer that account by will. So I will tell you the same thing. If you have small bank or brokerage accounts, this is the first ding moment. I want you to go to that bank and say, hey, I'm naming a beneficiary. You can name a charity if you want as well. Anything that's owned by trusts, which we will talk about a little bit later. And then anything that's already considered under a contract, like a prenuptial agreement or a partnership agreement. Those things transfer outside of will because they supersede, because we already know who gets the property. The only thing that is transferred by a will is stuff that we don't know who gets it until after you have died, and we still haven't figured out who it is. Thus, we have to look at the will. The bank account that I had with $800 in it, that's in my name and didn't have a transfer on death beneficiary. We don't know who gets it. It's still in my name. We have to look at the will. So that's why I say for these small accounts, it really doesn't make a lot of sense to do that because now you need to find an attorney to fill in the probate petition. It's a pain in the neck. Small accounts, name is transfer on death. Anything that you have left in your name after you die is transferred by your will. And remember, for example, if you're married, let's go back one more slide just so we can see this. Remember, if I'm married, a lot of these assets are probably going to my spouse. So typically when we have a married couple, we don't need to probate the first spouse's property because it's all going typically to the second spouse, the surviving spouse. When the second spouse dies, then we don't always have named beneficiaries on everything. So we're often able to avoid probate on the first spouse, but not necessarily the second one. Now, what does transfer by will? Anything that is in my name and it isn't left to a beneficiary outside of the will, like that transfer on death account or jointly owned, etc. Bank accounts or a home solely owned by me. If it's jointly owned, it goes to the other joint owner when I pass away. Personal property, my stuff, you know, that dreaded armoire I brought up. I hate armoires. Well, now someone else gets to get that property. I can say who gets it, and I leave it to my ex-girlfriend, and it's heavy. Anything else not transferred by operation of law, those other accounts that we discussed before. And any property that you say in your beneficiary designation form to my estate, that is interpreted to mean my probate estate. So I have seen clients who have a life insurance policy and they make an erudite decision and they think they're sophisticated and they leave their life insurance policy to my estate. Or they leave their retirement plan to my estate. And they think they're being all sneaky and sophisticated. And what they really did is they just screwed themselves over. Because they could have had that property just transfer with a death certificate under operation of law. But what they said is, I'm going to leave this via my will. If someone like me tells you to do that, you should do it. I've probably done it 3 times in the last 10 years. And I've been in practice for longer than that. Never, never, ever, ever, never, ever, ever name my estate as your beneficiary on your life insurance or your retirement plan. Enough stated. Now, this is the other thing that people are surprised to see. When someone passes away, we have to put people on notice that you have passed away. If you have no will, for example, and you still have property in your name, like let's say I left all my retirement plans to my brothers and sisters, and I left my bank account transfer on death, but there's the house that's in my name. And now I die, it needs to get sold, but I didn't make a will because I figured, who really cares? Let's let them deal with it. The state has a default. Now I put New York in here because I can't put in 17 different states. It's just, we don't have the time. But in New York, it says this: if I am married and have no children, my spouse gets 100% of that property that would have otherwise passed under my will, but for the fact I didn't have one. After that, my spouse and child, first my spouse gets $50,000, and then they split the rest, 50%, 50%. So when I get a couple in here, and it's husband and wife, and I say, hey, guess what, husband, guess what, wife, you're only getting $50,000 plus half of what's left, I usually know that I'm going to close that deal, because that is not a default that most people want. If you're not married, but you do have children, everything goes to your children, or if a child's passed away, then to that child's children, your grandchildren. If you have no spouse or children, it goes to your parents. I'm going to assume your parents have passed away before you, so then it goes to your brothers and sisters. And then it goes to your nieces and nephews if your brothers and sisters have predeceased you. So just keep that in mind. So you see, the further out you go, that is how we give property. If you have no person before in this list, like let's say I have, both my parents have died and I have siblings, then everyone before then is irrelevant, and everyone after my siblings is also irrelevant because I don't have 1, 2, 3, or 4. I just have siblings, so we don't need to look at my grandparents. Here's the thing. When I have a will, I have to put this order of people on notice. This is what I mean. If I'm unmarried and I have no children, and my parents have passed away, I may not be close to my siblings. Well, my will say, I leave absolutely nothing to Andy and Jessica. I despise them, and I question whether they're actually my siblings. Pretty harsh stuff, right? So I put that in the will, and then I say, I leave everything to my best friend, Maud. Well, they are my next of kin. Andy and Jessica, my brother and sister, receive a copy of that will. They have to receive a copy of that will because, you see, they are my next of kin. They have to get placed on notice. Now, in my case, I'm married and I have no kids, so it goes directly to my wife, Michelle. She's the only one. That's easy. But most people, if they're unmarried and have no children, I'm going to assume your parents have died before you, which is typically the case. Their next in line is their siblings, even if you cut them out. And after that, it's aunts and uncles. You may not be that close to them, or they may be dead, which then means cousins. But you may not want to leave anything to your cousins. After all of that, the state gets put on notice, and they're the ones that are in control. So up to your first cousins, you're good. Which then brings us to trusts. Now, a trust, again, is something that I create. It's a written and signed legal document. It names a creating, administering, and beneficial party. There are 3 parties to a trust, 3 people. It states the terms in which the assets that are owned by that trust are going to be administered and distributed. It avoids court oversight, unlike a will, which is requiring the court to oversee it in the state in which you live in or die in. The court does not oversee trusts. The trust continues to exist after you're alive. So you create it during your life and it's in effect. Your will is not in effect till you die, but your trust is. And it only impacts property that's owned by the trust. So if I create a trust with a quickie-dicky law firm, and they say, great, here's your document, and I don't change the deed to my house to the trust, when I die, that house is still in my name. It never made it into the trust. You have to fund your trust. So if you go to an attorney and you say, create a trust, and they don't talk about funding the trust, you got taken for a ride. Just want people to know that. And here's a good slide that shows the difference between wills and trusts. And I'll stop here and take a moment so people have a chance to bring it in. Wills transfer by the process known as probate. It's public. When the will is given to the court, they will upload that will, and everyone who stops by the courthouse can look at that will. Yep, once you die, your will, once it's given to the court, is public knowledge. A trust is private, doesn't go to a court at all. The burden of proof is on the executor. Remember, I wanted to cut out my brother and sister. Well, I need their permission. And they're going to try to fight the will because they're going to say, we don't want Maud to get this money. If we can knock out this will, we get it all. So that's the problem. And it's kind of a cruddy thing about probate, but that's just the way it works. Don't hate the player, hate the game. However, with a trust, if you do consider that family members might contest, how are they even going to know about the trust? Because it's private, it's not public. And number two, you don't have to get their permission to distribute property under a trust. So trusts tend to be beneficial in that regard as well. Wills have the state that is involved, so it's slow and more expensive to administer to. No offense to anyone who works for the state, but you all work for Nielsen, so let's make fun of government workers. It's very difficult working with the courts. I can tell you, and I get paid to do it. It's typically better to avoid the courts. So it takes me about 3 to 4 months in a simple case to help a family after we've turned in the paperwork to the court. So it's more like 4 or 5 months before anything's really done with the will. With a trust, your body can still be warm. I just need an original death certificate and we can begin working with a trust. It's fast and there's minimal administration costs because you did most of the work up front in funding the trust. To execute a will requires very little mental capacity. You just kind of have to know who your family members are and kind of the nature of your worth. If you say, oh, I'm as rich as the Queen of England and you only have, a minimal pot to pee in, you probably don't have mental capacity. But generally speaking, it's a pretty low level of mental capacity. If someone's unconscious, by the way, they can't execute a will. A trust requires a little bit greater competency as far as mental capacity goes. And last but not least, the trust just needs to be executed to be in effect. So in other words, if I sign a will, this is what I'm saying. I'm just having a legal document and I'm letting someone else deal with the problems later. I'm not going to deal with any of this property. If the trust, you have to fund the trust up front. That's the biggest downside, plus the additional cost you got to pay me or Susie Ormond, or whoever creates your trust. In order to execute your trust, it's only part of it. You need to change the titling of your assets. So you're doing all the work up front with the trust. You're changing the assets. You're having it named after the trust. You're changing the beneficiary of your life insurance policy to the trust. You are doing that. With the will, you're saying, I'll let someone else deal with this. It's going to be dealt with later. That's the biggest difference between a will and the trust. You do the work up front with the trust. You let someone else do it after you've died with a will. Now, who are the parties to trusts? Like I said, there are 3 different individuals, or they can be multiple individuals, each category. There's a person that creates the trust. That's called the creator. We also call them the settlor. And they fund the trust. They change the brokerage account from Daniel Timins to the Daniel Timins Living Trust. The trustee manages the property. Remember that brokerage account I just told you that went in there? Maybe I want to move out of Time Warner and go into Nielsen stock. I can do that. That's what the trustee does. And they also pay the income tax returns, and they get a minimal commission. And then I like to say the beneficiary just sits back and enjoys the cool, hard cash. Beneficiary just gets the benefits from the trust. The interesting thing when you look at this is like your life right now, right? You're creating money at work, and you're administering to it so that you can go on vacation and eat good food, etc., etc. So you can be all 3 of these parties. This is what we typically call a revocable trust or a living trust because you're in full control of it. It is your alter ego. Now, why would you do that? Well, here's why. It allows for continuity of finance. If I'm alive but I get a stroke, my backup trustee can continue to take care of me because I'm the beneficiary. And once I do pass away, like we said before, there's privacy. It's not a court document. A trust has no probate fees. You do not probate a trust. It's easier distributions. It only takes me a few hours to help people begin administering to a trust. And you can have more flexibility in the terms of distribution. And again, just to review, these are the people who create a revocable living trust. This is probably the trust that I create 70% of the time. This is the popular thing. If you have an iPhone, you should have a trust. This is the popular thing. In fact, if you have a Samsung, get a trust too. So again, same thing. You are the creator, you are the trustee, and you're the beneficiary. If you're incapacitated, you name a child, a friend, a family member, your accountant, your attorney, your family neighborhood attorney to be your trustee. Beneficiaries, you remain the trustee until you pass away, and after that, your children, friends, family, charity, whoever you want is the beneficiary. And again, it avoids probate, so it's pretty easy. Now, some people talk about irrevocable trusts. Before you get too excited about irrevocable trusts, remember with the revocable trust, you can change it. You can modify it. You know, if I name my nephew Jimmy as my beneficiary and then Jimmy disrespects me, he's out, right? Boom. I can change that in a revocable trust. But an irrevocable trust, I can't do that, right? You're stuck with the document. And once you put money in there, you're stuck with the money being stuck in there. And people say, well, why the heck do I want an irrevocable trust? And the truth is, you most likely do not. There are 3 times when you do. When you want creditor protection for yourself, you create a very specific trust. I put, a general construction worker, an architect, an OBGYN, someone who's going to get sued before the end of today. They may want to be in this position. Because the big thing is it's an irrevocable trust, number 1. Number 2, by the way, you can't be both the beneficiary and the trustee. I'll get back to that. So if you're looking for creditor protection, you may want to have certain types of irrevocable trusts. Not all irrevocable trusts will give you creditor protection. Number 2, you're uber wealthy and you want to save money on estate taxes. You can only do that substantially with an irrevocable trust. Now again, you can pass $11.4 million when you die without paying a federal estate tax. That's a lot of money. This is something that my clients who have $50 million are excited about. If you have $6 or $7 million, you should still be excited. You're better off than the vast majority of people out there, but you don't have to worry about an irrevocable trust necessarily. Or to procure government benefits. This is probably 10% of the trusts that I draft, maybe even more. These are people who want to qualify for Medicaid. Your mom doesn't have a lot of money and she wants to make sure you get the house, even if she goes to a nursing home. Boom, irrevocable Medicaid trust. The trust must be irrevocable. If you have a revocable trust, you or your family member will not qualify for government benefits. It must be irrevocable, and it must be, frankly, a Medicaid complying trust. It can't just be irrevocable. Each of these trusts are very different language inside of it. So just because you have a trust that covers one, most likely the other 2 categories are not covered. Now, here's the thing. Someone is giving up control over their property. And that's why the IRS says we'll give you estate tax benefits. That's why the government says, you know what, we'll give you Medicaid benefits or some other form of benefits. And that's why the courts say we're going to give you creditor protection, because you gave up control up front. Right? These are the parties to an irrevocable trust. Remember before, it was you, and you. Well, here, it's not. You or your family member creates the trust, but there's a big line, and this line is right in between the trustee and the beneficiary. You cannot be both of these parties. No, no, no. It's one or the other. Whoops, sorry about that. So I want to make that very clear. With irrevocable trust, you cannot create the trust, be in charge of the trust, and also be the beneficiary. You can, but it's just, it doesn't fulfill the purpose that you're looking for, which is creditor protection, government programs, or saving money on estate taxes. I'll spend a brief moment going over different types of taxes because I feel like this program is best understood in that context regarding what different types of taxes that we deal with are. When you're dealing with your own personal affairs, I know you pay sales tax or real estate taxes. I feel for you. I really do. But there's very little that I can do about that. Your spending is what controls that. The 3 taxes that someone like me is concerned with are income taxes. That's the taxes you pay on what you earn. Capital gains taxes. Those are taxes on investments, and specifically ones you made money on. And then when you transfer money to other people, those are known as gift and estate taxes. Those are the only 3 categories of taxes that I personally care about, because that's all I have control over with you or have help with you. Can't stop you from eating gummy bears and paying the sales tax. Now remember, sometimes a state, not just the federal government, a state may also have some or all of these taxes. This lovely state of New York, we have all of them except gift taxes, but we do have estate taxes. Anyway, no one's lived in New York as a financial proposition for quite some time, I might add. Income taxes. Let's just go over these quickly. It's the money that you earn and you pay a tax on it. Because congratulations, you worked hard. Now we're going to tax you. Now, earned income is what you pay taxes on for what you labor for. So your job. That is going to be earned income. You have to pay Social Security and Medicare taxes out of that, as well as income tax. Now, unearned income is like if you own a piece of rental real estate or an investment account that's generating dividends or income. If you're getting rent or you're getting dividends or you get some interest at your bank, yeah, probably like 2 cents if you have a $10,000 balance there for the year. That's unearned income. You do not pay Social Security or Medicare taxes on that. But you also can't use that money to fund your retirement plan. You know, your 401k, 403b, IRA, et cetera, et cetera. Those are based off of earned income, not unearned income. And just as a side note, I give a hint, transferring money to other people may decrease your overall income taxes. It really depends. You have to transfer the asset as opposed to the income that's generating that income. And that's how you pay less taxes. But of course, everyone pays different levels of income taxes. Capital gains taxes are important because these are the investments outside of your retirement plan. Anything in a retirement plan, by the way, comes out as income taxes. Capital gains is on everything outside, including a house that you own. And it's only on appreciated investments. Now, let's say I bought IBM stock. And I bought it at $10 a share 30 years ago. And now I give it to my son. And now it's worth 100. Well, I got to change this example to Amazon at some point. We're going to do it now. I bought Amazon 20 years ago at 10, and now it's worth 100. And I give it to my son. When he sells it, his cost basis is what I purchased it for. We say donee takes the donor's basis. My son, the recipient, takes my cost basis in the Amazon stock. Why is that a big deal? What's the asset that most of your parents are going to leave to you? It's going to be your house, their house. What if they leave it to you while they are alive so they can qualify for Medicaid? Well, you're getting their cost basis. So their $500 house, which they bought for like $500, their $500,000 house, I should say, which they bought for $500, you're going to pay all those taxes. So it's always best to gift taxes that have minimal gains on them because the donee takes the donor's basis. The recipient gets the same cost basis as the person who gave it to them. Now, again, you do not receive someone else's capital loss. So if I bought, let's say I bought actually IBM 10 years ago and now it's lost money, I can't give that to my son and say, all right, now take an income tax write-off. He gets it at today's value. So it's kind of like the lower. So it's kind of cruddy, right? You made a bad investment decision and now you're stuck with it. You gotta sell it yourself and eat the tax loss yourself. Now, if someone passes away, that Amazon stock that I bought for 10 and is now worth 100, if I die and leave it to my son under those circumstances, he gets it at $100 a share. Same with the house. If your parents are holding on to the house when they die, that house they bought for $500 and is now worth $500,000, your cost basis is $500,000. We call that a step up in basis. When someone dies, they get a step up in cost basis. So again, the moral of the story is, if there is a highly appreciated asset like that IBM stock that I am now using Amazon as the example for, or that house, you probably don't want to transfer that. You probably want to transfer to kids or from a family member to yourself, something that's pretty close to the same value. You purchase it at the same value as it's worth today. Cash is great because cash accounts are at today's value. Next is gift and estate taxes. I'll cover these relatively quickly. These taxes are on things that are transferred. This doesn't affect too many people as it is right now. On this call, it may or may not. If you're worth more than $11.4 million, I highly suggest you talk to an attorney and an accountant. And you tell them how much you have and say, by the way, you're taking me out to lunch, and make sure it's a good place. Spouses never pay transfer taxes. So gift and estate taxes, if I leave $1 billion to my wife, lucky her and lucky me, or at least lucky her. She never pays a gift or estate tax on that. I'm going to pass the rest of these slides if only based on time, but you see, I just want to show you, most of you will never pay a federal gift or estate tax. Just by way of illustration, I think in Connecticut, the current gift tax starts at $2 million. At New York, it's approximately $5.5 million. Florida, there's no estate taxes. So it just depends. This is just the federal amount. You could owe for both the federal and the state. And that's why I bring this up in this slide. Just be warned, there's always expenses. There's always taxes everywhere. Now, I have some people that want to gift money to younger individuals. Remember, a minor cannot own property. I had a client once who was riding his bike by the Delaware Water Gap and he got crushed by a truck. Yes, he died. I mean, it was awful. He left a $2 million life insurance policy to his 13-year-old daughter. And if something seems wrong when you say, well, if I was 13 and I had $2 million, I may not know what I was doing, you're right. The law says you cannot own property when you're a minor without an adult named on the account with you. Here's what happens. You all have life insurance policies. If you're married and you have kids, you name your spouse as number one, and then you name your 6-year-old kid as your contingent beneficiary if you and your husband or wife die on your plane flight together. Not good. Now, there are other ways that we can do this. We can use trusts, or we can use what are called Uniform Transfer to Minors Act accounts, or you can give the money in a 529 plan. I talk about UTMAs briefly because I don't think UTMAs are great accounts. This is the Uniform Transfer to Minors Act accounts. You would name a custodian for your child. You want to give $50,000 to your kids, so you name your husband as the custodian over your child's account. You put that $50,000 in the account. Now, it gets taxed at that kid's income tax rate, which is typically going to be lower than yours. That's great. And you can invest in almost anything. But when that child turns 21 years old and they're dating the guy with the tattoo and they're doing drugs and they have terrible credit history, they get the money. I had a mom take out like $120,000 out of her son's UTMA because he was in a bad condition. She got sued and she lost. That's why I don't like UTMAs. It just doesn't give any flexibility. The person's 21 years old, boom. It's all going to drugs or their credit cards, or if they're disabled, it's keeping them invalid for Medicaid benefits. So not good. The only benefit is that it's a cheap alternative for trusts. If it's a small amount of money, a few $1,000, maybe use an UTMA. It's very cheap. You don't need an attorney to create a trust. However, in other circumstances, if it's large amounts of money, I suggest you pay the attorney. You'll probably be doing yourself and your child a favor. 529 plans, I'll just tell you really quickly that just because you place money in a 529 plan, if you're the owner, doesn't mean it's stuck in there. In fact, if your mother-in-law and father-in-law give you a check for $20,000 and say, put this into the 529 plan for Timmy and Jenny, you could take that money back out if you're the owner on the plan. So if you are going to give money to a child for a 529 plan for your grandchildren, make sure it goes to a 529 plan where your child is the owner. Not saying your child's going to get divorced, and I'm sure your in-law, son-in-law, or daughter-in-law is perfectly fine. But isn't it better to do it that way 9 out of 10 times? Sometimes, let's face it, like our kids are just complete mess up. But generally speaking, if you're going to give money to them for a 529 plan, that's good. The one thing I will say is that student loan funding, if a parent owns the 529 plan, it affects the student loan and the FAFSA form. But if the grandparent owns the 529 plan, doesn't affect FAFSA. It's a good reason to have grandparents be the owner on 529 plans. Make sure you name a backup owner as well, just in case. Otherwise, if it goes through probate, and we already said we don't want to do that. You know, Medicare, I'm going to kind of skip just because of time. Sorry, I kind of pick and choose what I think are the hotter topics at the time. If you need Medicare, this is what it is. Part A is inpatient hospital care. That's what you're paying for right now out of your paycheck. When you go to hospitals, you still get copays and deductibles, but otherwise it's covered. Part B is the supplemental medical insurance. That's visiting other doctors and getting procedures. That's what you pay out of Social Security. They're going to take it directly out of your Social Security. You haven't paid for that yet. You will in the future. Part C is optional. It's managed care program. That says that I want to avoid some of the premiums and copays that Dan, me, suggested in Part A or discussed Part A. Then Part D, prescription drug benefits. I really suggest that if you're approaching retirement age and Medicare is getting to be a reality, you really educate yourself on it. And feel free to, look at this presentation again online. I know I'm going relatively quick, but you probably also want to do more research anyway. Medicare is a very rich and important field. Now let's go to your mother or father or Aunt Selma who is disabled and needs Medicaid. Medicaid is a healthcare program that assists families and individuals in paying for long-term care medical costs. It's a program funded by the federal government, and it's run at the state and county level, and coverage, exemptions, and costs vary. I can tell you, having prior been in Westchester County, New York, that was the gold standard, the platinum standard. Everything that you could possibly want was exempted and covered under Medicaid in Westchester. We used to move people from other states into Westchester. You can still do that in Nassau County, New York as well. But again, varies state by state, county by county. Aunt Selma gets a stroke and she needs help walking or feeding herself or toileting or eating. The fact that Aunt Selma doesn't have stage 4 cancer is irrelevant. We're talking about activities of daily living, not what is the condition that she has. That's what's important with Medicaid. The person can't do basic functions. I've seen people with stage 4 cancer who can do all these things just fine. They're dying, though. They're clearly going to die. That's not what Medicaid's about. Medicaid is basically long-term care without the insurance policy, just not nearly as good. This is what Medicaid covers. Now, Medicaid is for the disabled, a child who is born disabled, someone who was not born disabled but becomes disabled, such as an elderly individual sometimes, or people who are not disabled who may become disabled. That's who Medicaid covers, people who are disabled. It can also be for people who are disabled and shall one day no longer be disabled, but again, you may want to avoid dealing with that issue yourself. Talk to an attorney. There are 2 types of care. Medicaid pays for care at home. We call that home care. And actually, attorneys call it community care because we want to sound smart. And the other kind is nursing home care. And we attorneys also want to sound kind of creepy, so we thought of an even worse term than nursing home. We call it institutional care. These are 2 different types of care. One can be done at home, surprise, surprise. The other has to be done at the institution, hospitals or medical facilities or nursing homes. Different types of care. Now, what does home care cover? Doesn't necessarily cover cooking or cleaning. This slide needs a little bit of updating. It really depends on state by state. But typically, Medicaid will not cover any fancy cooking. Yeah, a home health aide will have to heat up something, but it doesn't have to be like a 4-course meal. Also, with home care, there's no guarantee as to how many hours the government's going to grant your aunt or uncle for care. Caregiver must be a qualified individual. I can't say, you know what, I'm going to pay my wife to take care of me. Government, pay my wife. Now, there are examples where you can have family members, at least in New York, and I believe in maybe Pennsylvania. I might be wrong. You can do a managed care program. But again, managed long-term care. I would suggest that you really talk to an attorney before you assume you're going to be able to pay a family caregiver. It's very hard to get 24-hour home care, And if you possibly need a nurse at some point within the next 24 hours consistently, you're going to a nursing home. Sorry, Aunt Bev, you're going to the nursing home. And then you get these people say, but I don't want to go to a nursing home. Well, I got good news for you. The nursing home doesn't want you there. The nursing home doesn't get paid a heck of a lot of money by Medicaid. It gets paid probably about 2/3 of what you and I would pay out of pocket. So they don't want you there unless you got to be there. But truth be told, it's like Starbucks money for them, and they have a lot of beds. They're a pretty big institution, so they say, well, all right, we'll accept it. But they'd rather get paid out of pocket, clearly, by someone who doesn't have Medicaid and doesn't qualify. So then people say, okay, I feel better. Let me out of here. Because a lot of people go to nursing homes just to rehabilitate. They break their hip, they break their knee or whatever, and then they get better after a few months. That's fine. But the nursing facility want to see their actual release plan before they are involved. Now, the nursing home can't force you out once you're admitted, but you can say, I'm leaving. So just keep that in mind as well. I put in New York limits. You see, you can't have a heck of a lot of money for Medicaid in New York. This is going to be even lower for other states. So like I said, Connecticut, the sick spouse or sick individual can only have $2,000 in their name. You're like, whoa, that's not a lot of money. No, it is not. Income for the sick spouse is limited to approximately $879 per month. If there is a well spouse, they're allowed to up to about $124,000 as far as assets go, and then income, they're allowed to $3,100 a month. Again, this is just New York. New York, like I said, is the platinum coast as far as Medicaid goes. Now, I have too much money to qualify for Medicaid because I have more than this amount in this prior slide. I got to give the money to my kid. If I do that, and here's the last important slide that we have, and I leave it to my child, after 1 month's time, I can get home care. Now, people always say, I thought it was 5 years. I thought it was 5 years. It was 5 years for nursing home care, but I only need 4 or 5 hours of care at home. I don't need a nurse in the next 24 hours. Well, then I qualify for home care after I transfer those assets 1 month later. As long as that next month later, I have this amount of money to my name. Not a big amount of money. Now, nursing homes are different. You got to get the money out of that person's name as soon as possible because you got to make it 5 years. I had a client who had a stroke, and it was clearly, like we could transfer the money, but they needed to go to a nursing home, and we were only going to be able to protect a small amount of it. And they were so upset because they said, I thought it was a month. I thought it was a month. I said, no, you had to make it 5 years. And they said, well, I put stuff into a trust 2 years ago, a Medicaid trust. I said, that's fine. You still have 3 more years. And there's no partial credit given on this. If you're going to do Medicaid, do it with a Medicaid attorney. That's how it works. I'm going to wrap up the last few slides here. Not every asset is included for Medicaid, and every piece of income, your retirement plan, is excluded. That's a good thing. So keep funding your retirement plans. And trust, Medicaid trusts help us to plan for Medicaid use. I'd love to have more time to go through this slide. If you ever have any questions, just Google my name. You'll see plenty of material regarding different types of Medicaid trusts. Today is too short to go through everything. And then last but not least, what are bad investments or good investments? If you have a non-qualified annuity and you want to qualify for Medicaid, not a good investment. There's a lot of tax built into there, and I got to get you under $15,450 in assets. Now I'm going to have to pay a lot of taxes on that. Permanent life insurance policy with large cash value, not good. Roth conversions, not good, because you pay income taxes converting from the IRA to the Roth, and then you still have to take required minimum distributions from the Roth, which you normally don't have to do, but for the fact that you are going on Medicaid. And anytime you turn a liquid asset into a fixed or lifetime income. So when I take money and I annuitize it, that's not great either. I would have loved to have talked to you more and listened to myself more at that matter. But that brings us to the end of today because I was told I need to leave 5 minutes for questions. So I'm going to do that. Thank you so much for your time. And if you have questions, this is the time to ask them.
Thanks, Daniel. And I do have some in here. If anybody else, has a question, feel free to type it into the question box. Oh, just a bunch of thank yous.
You're welcome.
I want to thank you as well because I feel like you really, a lot of times when you speak to people that are in a certain field, whether it's, a doctor or a lawyer or whatever, it's, I always tell them, dumb it down for me, please. So I feel like you spoke, pretty plainly about things, explain them clearly, give great scenarios, of different things that could be happening. Everybody has different family lives, different situations. So I do appreciate that.
I'm a man of the people.
Exactly. So I don't see anything else coming through. So I want to thank you for your time today. Here's some coming through now.
And as those are coming through, if you have any questions, you can always contact, your insurance company or your insurance plan, covers Zimmet Law Group. So feel free to contact our firm and ask questions too.
Okay, great. I do see one here. Is there a threshold when a trust is better than a will?
In an ideal world, everyone has a revocable living trust and it is fully funded with all their property. But again, I say in a perfect world. In a perfect world, I don't cheat on my diet and I go to the gym 5 days a week and I get 7.5 hours of sleep every night. So is there a desirable time? I would say usually there is. When I would say that a trust is highly preferable is when you're trying to cut people out of your estate, when you want to maintain privacy, or if you have family members or friends overseas that you're either leaving money to or not leaving money to, but they're close relatives. Last but not least, if you want to make sure that you have a child who may have drug addiction problems, or they may have married a guy or girl that you don't support or you're not happy with, you may want to have a trust as well to try to protect the money a little more. And we talk about that more next week.
Okay, and so maybe that's the next question could wait for next week. It's, what's the, is there a particular age recommended to start a trust?
No recommended age, because there's so many different types of trusts. If I'm disabled and I'm 19 years old, I need a trust already. I need a Medicaid type of trust called the Supplemental Needs Trust, which we will cover next week. I would typically say that the people who I work with the most who want trusts are either people who have, low seven figures of assets plus life insurance, if you include in life insurance, so a few $1,000,000, and they have minor children. That's probably a good example. And people who have complicated estates and don't want the state to be involved in trying to figure it out. Most of my clients, though, who do have trusts are just like most of my clients to begin with. Other than young couples, the majority of people I meet with are probably right around retirement age, 60 to 75. And a lot of them prefer trusts.
Okay, great. Thank you. And the last question I have here is, are there taxes on Social Security and pensions in retirement?
Oh, yes, there are. Pensions are easy. Pensions, unless you're talking about, like, if you're a New Jersey employee, for example, and then you retire and you are living in New Jersey income taxes do not apply to you. But otherwise, and that's going to be the case state to state, depending on the different place. But you're always going to have a federal tax on a pension because you never paid income taxes on it yet. As far as state income taxes, it all depends. Florida, for example, and 6 other states have no state income tax. New York allows for your retirement plan $20,000 to pass state income tax free. So if you live in New York and you have a required minimum distribution of $10,000 this year, you don't owe New York any income tax, but you do owe the federal government. Social Security is a little more complicated. It all depends on how much your income is. The higher your income is, the higher the amount of Social Security that could be taxable.
Okay, great. Thank you for that. That's actually, we ended right on the hour. That's it with the questions. And I'll remind everybody that we're continuing part 2 next week. So I appreciate, Daniel, your time today, and I look forward to the second segment of this.
Thank you so much, Kelly. Have a great week, everybody. Make lots of money.
Thanks, everybody. Take care. Bye-bye.